Thank you, Mr. President. I'll be brief. I think one of the major things that we've been discussing here basically has been concerning this bill has been concerns about openness and transparency and fairness that it has or has not taken place. And I want to also echo those concerns, but want to emphasize that this openness and transparency, which is missing, is also missing in the area when we start talking about compliance with the Voting Rights Act of 1965. And this becomes extremely important. We have been told now that this particular bill fits the Voting Rights Act of 1965, but the dialogue has not been public or open or had an open vetting process to actually determine this. Has it actually been openly debated or discussed in any real manner that not only us as legislators can be assured of that, but also the citizens of the state can be assured of that? And that becomes very important when you understand our state, like many others. Georgia, like other states, when we did have Section 5 being a covered jurisdiction, was what we call a covered jurisdiction. And it was also mentioned Augusta was one when we had Section 5. And other localities have also been that too. And I think many times when we start talking about being covered jurisdictions, we look at it from a standpoint of almost like a punishment, but it really isn't. What it really is a recognition. It's a recognition of past issues that have taken place in the area of voting. It's a recognition that there has been infringement on the rights of minority communities, especially the African American community. It is a recognition that unfortunately African Americans were subject to state-sponsored and state-sanctioned discrimination in the area of voting. And that discrimination took many forms, whether from the standpoint of literacy tests, poll taxes, harassment of voters, or tolerance even of physical violence, to this actual framework of death to persons who wanted to register or actually go vote. So when we had the aspect of covered jurisdictions, it's not a punishment but a recognition. So it tells us how important it is to have an open dialogue when we talk about the Voting Rights Act. When we talk about the Voting Rights Act, we also put it in perspective that when the Civil Rights Act of 1964 and the Voting Rights Act of 1965 was passed, our United States senators from Georgia actually voted against both provisions. Our congressional delegation actually voted against both provisions. So when we have these conversations in this state, we come from it from a unique perspective. And it becomes important to make sure that we have open conversation and open dialogue. And then when we couple all of this with the fact that now our state is becoming more diverse, when we realize that our Hispanic population, our Asian population is increasing, the concern of having an open dialogue and an open, transparent process as far as the Voting Rights Act is concerned becomes even greater, because Section 2 of the Voting Rights Act applies across the board. Basically says that you cannot abridge a person's right to vote based on their race or color. So Georgia not only historically is fit within Section 2 in the Voting Rights Act, we see even now today, because we've become so diverse, that it fits squarely within the ambit of the Voting Rights Act in Section 2. So therefore, even though we've been assured that it fits, and we've even been given numbers to say, see, look at these numbers, this shows you that it fits, our concern is that there hasn't been that open dialogue. Our concern is there hasn't been that open vetting process to actually make an assurance of that. Because we realize that our history, number one, and our changing demographics, number two, makes it a very special case that we need to do that. We need to make sure that we're following these steps in everywhere possible. How would we do that? What would that even look like? How would we determine that? You know, what would that dialogue actually be? For one, we would have to make a determination whether we have racially polarized voting. And actually, in one of our hearings, the chair of redistricting said we did have racially polarized voting. But that's just not a term. When we say we have racially polarized voting, we ought to immediately take a pause, because that means something. It means something within the framework of the Voting Rights Act. It means something within the framework of what we call vote dilution claims. It means that at that point in time, we really have to start going slower, because that aspect of having racially polarized voting is one of the linchpins to Section 2 violations. So when we say, yeah, we got racially polarized voting in Georgia, or we have racially polarized voting in different localities, immediately we got to put a pause to all of this and say, let's talk about where we're heading. So number one, we would have the notion of whether we still have that. Secondly, we'd have to have a discussion about the extent that minority members, in particular, whether it's in the state or political subdivision, have borne the effects of discrimination. Whether those effects have affected their employment, their health care, education, which has hindered their ability to go to the ballot box. All of this is the things that the court is going to be looking at when they look at this particular bill. We should be doing that now. Another thing that we should be talking about is whether we've had political campaigns that actually appeal to racial animus or racial sentiments. These are things that the court is going to be looking at. So when our senator says we're going to court, certainly we realize that that probably will take place. These are the exact aspects that the court is going to look at. They're going to look at Georgia's history. They're going to look at the acknowledgement that we have racially polarized voting, and then they're going to start looking at these factors. And our point is, why haven't we looked at these factors already? Why have we not already looked at these factors and made a determination, not just by results, but made a determination whether it's from a holistic standpoint from the state of Georgia or an individual standpoint from each of our individual Senate districts, that we have satisfied the Voting Rights Act. That's our concern. And we should not rush through that. Our history tells us, our change in demographics tells us that the Voting Rights Act is there to help us, help our citizens make sure that they can achieve the American dream. It makes sure that America continues to be the greatest nation on earth. It's not a matter of punishment. It's a matter of recognition and to make sure that all of us participate in the great American experiment. And so our concern is that we haven't been open. We haven't been as transparent as we should on this particular issue, on this issue of the Voting Rights Act. And that is why I today stand in opposition to this, among many other reasons. But we have not done that. We have not done the in-depth analysis, some of those things that I don't understand, whether you're talking about what they call homogeneous analysis for different precincts or bifurcation of precincts, all sorts of types of analysis that takes place. We haven't done it. And it's not only for us, but it's for everyone that's watching to realize that we're going to make sure that our citizens are protected. As stated, it's not a matter of punishment. It's a matter to ensure that we continue to be one American family. And with that, I will yield for any questions, Mr. President, if there are any.
Chair recognizes the senator from the 56th.
Yes.
Thank you, Mr. President. Will the senator yield?
Yes.
Senator, thank you for those comments. And one that struck me as certainly very concerning was the Voting Rights Act of 1965. Is it not true, you mentioned in your comments, that all the senators and representatives from Georgia and the federal government voted against the Voting Rights Act?
That's
Is that
correct.
not true? Senator, would you yield for a further question? Yes. Could you please, for everyone's edification, tell them what party they represented in all those positions?
They were part of the Democratic Party, but I also would say that the first Republican that won after Reconstruction to Congress, Bo Calloway, was a strict segregationist. And he actually won because he actually opposed integration. So we can actually go through this kind of game. We can play it all day long, and I understand what you're saying. And that's why I realized when I said that that would be brought up. Because the consistent factor in all of this is not about the parties. The consistent factor has been that black bodies and African Americans have been used as pawns as far as political power is concerned in this country. So we want to talk about the fact that, Richard Nixon was a Republican president, created a drug war, which his own chief of staff has said was designed to harm African Americans. We want to talk about the fact that a Republican president, Ronald Reagan, made his announcement speech in Philadelphia, Mississippi, and talked about states' rights when, in fact, 3 civil rights workers were killed in that particular county. We can play the game all day long. I said that on purpose because I understood that that would be brought out, because I want to bring out that the key thing is not about the individual parties, but about the fact that African Americans and other minorities have been pawns in political power for both parties. And that is why you have the Voting Rights Act of 1965. That is why you have Section 2. That is why you have covered jurisdiction, is to protect those minority communities from both parties, which has historically used African Americans especially and other minorities as pawns in political power.
Senator, will you yield for another question?
Yes.
So let's shift away from political parties and talk about people. So in the year 2001, during redistricting, the Georgia General Assembly passed maps that were found to be illegal, found to be unconstitutional,
Correct.
found to be a violation of the Voting Rights Act. In fact, I believe you went to the University of Georgia, and in your textbook, you may have even seen, before or after, the worst modern-day form of gerrymandering map that is actually in textbooks throughout the nation, even today. And those maps that were passed, were they not thrown out by a federal judge, and the judge redrew those maps? Is that not
Yeah,
true?
I actually went to HBCU, South Carolina State University, but actually, if you also know about that, if you know your history, the Attorney General who was responsible for actually pre-clearing those maps said that he was a Republican, and basically they were playing political games as far as that was concerned. You had what was called something like the Max Black Plan or something of that nature. So you have both parties once again playing games. But I'll tell you what's more important than what happened 18 years ago when I was not here. What's more important is SB 202, which most persons say was basically a recall back to Jim Crow, which this body passed with no Democratic support.
Well, Senator, if I could ask you another question here, getting back to the
Absolutely.
matter at hand. Isn't this the voting records of 2001 in my hand, where almost half of your colleagues that are still here 20 years later, which we could probably have a discussion about that, voted in favor for it unconstitutional, illegal, violation of the Voting Rights Act, most modern-day form of gerrymandering ever, and they're in this chamber today.
And I would also say that one of the reasons why they also participated in, if it wasn't a gerrymander, was because they were trying to also increase African-American participation. If you actually understand all the different things that was really going on in that particular situation, I question whether you want to say it was illegal and things, terminology like that, but there actually was a desire to increase African-American participation, to actually try to go with the Voting Rights Act of 1965, quite frankly.
Senator, will you yield
and
for
that's
one more
important to
question?
understand that, too. It wasn't a desire to actually restrict African-American voting. It was actually a desire to actually try to promote African-American voting, actually promote African-Americans getting elected. That was the desire. Now, whether that desire was done correctly or not, that's debatable. But I can tell you this, no one thinks that the desire of SB 202 was to increase African-American participation.
Senator, yield for one more question. Senator, isn't it true that the voting map in 2001, as in college textbooks, as the worst modern-day form of gerrymandering, as voted on by almost half of your current caucus, actually had lines drawn from one end of Georgia to the whole other side of Georgia, down the interstate for 20, 30, 50, 70 miles in order to pick up neighborhoods and districts? And some of the folks here today voted for that map, and then some of those same folks then voted against the map that was pre-cleared and found to be in good standing with then President Obama's Justice Administration and Eric Holder as the Attorney General in 2011.
And as I stated, one of the reasons that they did that, and whether that was correct or not, and we can have a debate about that, and I can debate you with that, whereas it also is trying to help African Americans get elected. I think that actually helped an African American female get elected to that particular position. And so when you have a history of racial discrimination, sometimes persons actually go above and beyond where maybe they should to try to rectify those past discrimination. So when you're talking about a history of over 200 years of racial discrimination, racial terror, racial injustice, sometimes persons do try to make that up.
Thank you, Senator.
Thank you.
You have no more questions.
Thank you.